if they ask you to come and present?
Of course, then we will.
you
Of course,
okay.
if you are able to accept an engagement on that particular at that particular time, and then you are able to be there, well and good.
Okay.
Judges also appreciated it.
After some point.
They said, okay, here is. That is what I was saying. The relationship between a senior advocate and a instructing counsel is a very delicate and a very important relationship. Each one has to develop that relationship in the manner he or she thinks appropriate. There is no rule. One is to be cut and dry. All right, you told me this, one point, thank you, go.
And even whether senior advocate should be present at the time of pronouncement of judgments.
There again, I think it is a matter of courtesy
to the court,
but not necessary.
I had thought like this, sir, so correct me if I am wrong. Generally, senior advocate should not be concerned about the outcome of the decision.
Correct.
The senior advocate should be concerned more whether all the points that are required to be put across and whether the case has been nicely put across to the court. So during the hearings, of course, now what happens at the end of it, unless you are seeking leave to appeal, unless you are seeking for a stay of that decision, then it is what I understood. But there is
one nuance to this.
Please, sir.
See, while I fully concur with you that you are not so involved emotionally with the result of the litigation, but there is what is called as intellectual curiosity. That should never fade.
Okay.
You always say, I argued this.
So, want to see what the judge...
What has the judge said about it? Not if the judge has accepted it, not that I feel elated about it. If the judge rejects, not that I feel depressed about it. Okay. What is the reason why the judge has accepted what I said or the judge has rejected what I said? Now, the other side also came up with some very good points against what I had said, but that has been rejected. Why has the judge rejected that?
Okay.
See, even where the other side's argument has been rejected, you still want to know why it has been rejected.
But that you will, of course, the judge won't read the entire decision at the time of pronouncement. Later on, of course, you will read. But at the time of pronouncement, let's say it's set out for 2:30 for pronouncement.
Yeah, but it depends upon the case. I mean, I don't think there is any such rule which I would like to either as a custom. It's all right.
It is left to their individual choices.
Because so many things that you will agree with me. Then many a time we don't even know the case is posted for judgment.
Yes, of course, because I won't know. Won't tell it.
Okay, then take care of it.
Yes,
it's taken care
of it. But if they ask you to come and present,
of course, then we will. Of course, if you are able to accept an engagement on that particular at that particular time, and then you are able to be there, well and good.
Okay. So these are like very not so, I would say, consequential.
No.
But some issues, sir, like for example, we had one where I was an advocate on record at that point of time. It was a very high stake matter. The matter did come before a division bench. And on that day, the judge said, we'll hear it on such a day. And the judge asked, what is this matter about? And, I was prepared. Maybe my anxiety, I must have told more than what may have required to be told or something. And then it was put another day. And then I was instructed to engage you, sir. You came on that day. And the judge took an exception to that. And I must thank you today that you sat along. I mean, I want to tell my viewers that on that day, the judge refused to hear sir. And sir said, I'm not going to argue, but I will sit around and I'll allow the AOR to argue. And I was nervous from the bench and sir sitting next to me. But anyway, we are not going to discuss what happened in the case.
No, but I like that, that was a very good experience for me. I also remember that incident very much.
Yes. So what do you say, sir?
It should be that way. Okay. The judge is the
final
authority to determine how the proceedings in court must go on. If the judge has said the advocate on record has already argued it last time and we would like to hear, nothing wrong about it.
So what you're saying, the senior advocate need not feel.
There are two ways of reacting to that.
But I look at it this way, sir. Sorry to butt you in. A senior advocate is to bring about clarity in a given situation, not to bring about a decision in a particular way. But if for some reason the immaturity of the counsel might have led to not putting things across in a difficult time, I can understand if the matter is posted further hearing. I can understand the matter is posted for disposal. the matter is posted for hearing, the judge out of curiosity may have heard, the judge may have made up the mind. Wouldn't you then be making the senior advocate redundant at that point?
No, that's one way of looking at it. The other way, and I think the more healthy way of looking at it is, all right.
To take it in the right spirit.
Ultimately, okay, whether I say it or the junior advocate say it doesn't really matter.
Okay.
The point has to be put across. Now, I remember in that case, I was showing you page numbers,
Yes, yes,
I was
sir.
showing you
Yes,
document,
sir.
I was whispering everything into your ears.
It was, I cannot tell you, I was like nervous both from your end, and I was thinking, what should I tell sir now? Because I told you that this is what happened. It went off beautifully. And the judge was so patient, he heard fully.
And I think judges also appreciated it.
After some point of time.
They said, okay, that is what I was saying, the relationship between a senior advocate and a instructing counsel is a very delicate and a very important relationship. Each one has to develop that relationship in the manner he or she thinks appropriate. There is no rule. One is to be cut and dry. All right, you told me this, one point, thank you, go.
No, sir, you were not like that. In fact, I was so scared where you will come and tell me, you put me to shame, you shouldn't have done this.
No.
So your attitude put me to ease, and I thought whatever was the case, so I really thank you on that day.
This is my duty, and that's why I do it. When the youngsters come to me, I say, do you really need me for this case?
Yes, you told that. Do you really need me for this case?
That's the way of putting it.
I learned, sir. I learned a lot in that. Sir, now I think we will, as I told you, I am quite envious about the way you have structured your profession, the way you have included that no FOMO. You are a book of yourself. You will go, and you are there where there are important cases. You are there. I don't know how you do it. What are the good qualities of an advocate, sir? What should he be fearful? What should he not be fearful?
I have 3 F's which are basic to be a good lawyer at whatever level.
For all advocates.
For all advocates,
Yes,
whether
sir.
you are starting your practice or whether you are at the pinnacle of your practice.
Correct. Okay.
What are those 3 F's? First, you must have the fear of the client.
Fear of the client.
Yes.
Yes.
You must understand that he or she is the person for whom you are standing up in court.
Okay.
And if you should always realize that if you don't do a good job, the client will come back to you and say, sir, I was very disappointed with what you did. And the client is entitled to say it.
Yes.
You should then have the inner strength and the humility to say, no, please come, sit down. I will explain to you what went wrong, why it has gone wrong. Instead of simply saying, well, I have finished, I have argued the case, that's the end of it, don't waste my time anymore. I don't think that's a fair way of dealing with the client.
You are saying we need to be accountable.
You need to be accountable.
To either the advocate on record or to the client.
And,
irrespective of what
And
position.
more importantly, when you lose a case.
When you lose a case. Okay.
See, when you lose a case, necessarily the client is agitated.
Of course.
For good reason or bad reason, that's a different matter. But to such a client, when the advocate on record and says, we want some more of your time because the client is a little upset, they want to know why we have lost the case. One way of reacting is say, well, I have argued it, that's all, you go and tell the client whatever you want to do, that my work is over. I don't believe that that's the right way. I said, okay, we will meet the client, talk to him and say, look, this is how it is, this is the reason why the judge has held against you. And this is your remedy. That is one fear. Therefore, you should never lose fear of the client. Second is fear of the court.
Fear of the court.
Yes. See, when we read a brief in our office, we may get an impression that mine is an open and shut case. But when you go to the court, your experience will tell you, my experience tells me, the court views it in such a different manner.
You are sometimes caught off guard.
Completely off guard. Therefore, you go to
with
court with a trepidation. Said, well, this is my view. I think it is an open and shut case, but I never know how the court is going to react. Therefore, don't take the court for granted.
Very true, sir.
A judge is a judge. A judge is entitled to look at the way completely different from the way in which you are looking at it as a lawyer.
Correct.
Point number 2. Third, you must always fear your opponent.
Opponent
Lawyer.
lawyer.
Go to court with the belief that your opponent lawyer is well prepared, better prepared than you are. Always say, well, have I missed some point which my opponent lawyer is going to point out? It doesn't really matter whether the opponent is a senior or a junior.
Yeah,
It doesn't really matter.
Surprises come in small packages, surprises comes in very shabby packages also.
Exactly.
Yes.
See, therefore, we have to take cognizance of the merit of my opposite lawyer.
Also.
Once we do that,
Then I think that is the last stage to be completely prepared. If you take all
these three, you have prepared yourself and
the best
you will do the best for your
I mean,
client.
I think as an advocate, that is the least a duty that we owe.
100%.
That we do the best, the best that you can in that circumstance.
100%. You are absolutely right.
I should feel, yes, I did the best.
I did the best which I could do.
Yeah, in that circumstances.
You see, there is a difference in saying, I did the best.
Not what, yeah.
I did the best which I can.
Which you could.
Somebody else can do much better, maybe. So I think this is what I would.
So 3Fs
3
formula.
Fs, don't forget. That's so important at any stage of your career.
Very nice.
Don't forget that. The moment you forget any one of these, then it is you're done injustice to yourself first, then injustice to the cause.
Okay.
Second, you should always be respectful to the court.
Yes, sir.
It is so important.
The nomenclature or the words may be different that you can choose to do, but respect is the underlying.
Respect to the court is, I think, without any compromise, one has to respect the court. Whether what the court does, what the court does not do is none of your concern. Each one must regulate his or her conduct in court. Judge also has to regulate his or her conduct. I am not going to preach what somebody else should do. I am only going to preach myself.
Yeah.
I can't even preach to the children at home.
True.
That is the stage we have come to. So, you set your standards according to what you believe is right and wrong.
So I think for that first, language is important, sir.
Very
you may choose whichever
very
language
important, very important.
Like recently, Chief Justice also was telling advocate says yeah in court.
Should not.
So
does it matter? It doesn't matter.
But it shows the respect to the court.
It should not do it.
So I think we have to start, our vocabulary also should be in conformity with.
See,
overall grooming.
Correct. For example, Anuradha, would you tell a judge, you didn't understand what I am saying?
That would be very rude. I mean, that's actually showing disrespect.
That's showing disrespect.
When it could be the truth.
It could be the truth, but you don't say it. How do we put it? He said, I'm sorry, I didn't make myself understood.
Clear, yeah. I didn't make myself clear. Can I just put it in this way?
Can I put it in a different way?
Yes.
Maybe I didn't, the fault lies in the way in which I put it.
Correct.
Maybe I should put it this way.
Correct.
That's a polite way of doing it.
Yeah, I mean, humility is
these are the hallmarks of a finished advocate.